All right, hi, I'm Jeff. I'm the divorce dude, and I'm going to talk you through today 3 different types of divorce. There are tons of different variations across America. It's really not fair that there are, but there are generally 3 different types of divorce processes generally, and each state and jurisdiction is a little bit different. The first one is a harmonious process. So that one is basically you've gotten together with your soon-to-be ex, you've decided that you don't love each other anymore, and you're going to work things out together. Be very careful so you don't falsely misplace trust in somebody who doesn't deserve it. But assuming that you can be harmonious, that is by far the best process, least contentious, least expensive, and fastest. And generally the way that that process works is you start out by filing the papers jointly. So you'll go on your local state or county's website. They'll have the divorce process, divorce papers. You can just look them up on Google, and you'll file those papers together jointly. They're not that complicated typically. You don't necessarily need a lawyer to file those papers. It just kind of says who you are, where you live, that you've lived there at least 90 days, that type of thing, and that you're filing for a divorce. Once you've done that, in the next month or 2, you're going to need to go through and get all of your records. So that's all your bank statements, all of your different assets, so you kind of know what you have and kind of make sure that you have a good handle on what you have. The next thing you and your soon-to-be ex need to discuss and agree on a parenting plan. That's the time together, that's holidays, things like who's going to pay for medical expenses and things like that. How you're going to divide your assets, so your houses, any stocks, any 401ks, bank accounts, credit card debt or other debt that you might have, cars, things like that. How you're going to divide those. Alimony, which is typically called maintenance these days. You may not need it, and I really think it's kind of stupid with few exceptions, but otherwise it's kind of stupid and unethical. But alimony, and then child support, which can make some sense in certain instances for sure. And then whether or not you're going to do a modifiable agreement or not modifiable. So if you do something that's modifiable, whatever you present to the judge, you're saying, going forward in the future, we'll never renegotiate this. It's a done deal. Or you can do something where it's modifiable, saying, hey, look, if I get cancer a year or 2 from now, or if she gets in a major car crash or whatever, we want to leave this open so we can come back and renegotiate this later if the current deal we work out doesn't work. So you need to kind of go through those things. Then the next month or 2, I would get with a lawyer for both of you, one lawyer for both of you, and have him or her draft a formal agreement that kind of codifies what you've agreed on, and it formalizes what you've agreed on. It's best to have a lawyer do that, because if you don't have a lawyer do it, and if there are any holes in it, if it's not properly written, she can come back later and basically reopen up the case and drill you later. So be very careful that I would have a lawyer review it, and just make sure that he or she kind of represents both of you, and one lawyer can do it. And it should only take them an hour or 2 to review your agreement and write something up. Then you file that agreement with the court. So that's a parenting plan, it's your sworn financial statements, it's kind of what you've agreed on. It can typically be a memorandum of understanding or something like that, but basically what you've agreed on needs to be written down. And then typically it's in the 3rd month after you have filed. It's usually 90 days out from the time you file. You have to wait that long. It's like a cooling off period, and the courts are pretty backed up. But typically then about 3 months out, that's when you'll meet with the judge. The judge will turn to each of you and make sure you fully understand and agree to what has been written down by the lawyer. And if you both say yes, the judge grants a divorce decree and you're done. The total cost of this type of approach, a harmonious approach, is about 3 months, give or take 3 to 4 months, and about $300 to $500, because really all you're paying for is court's filing fees and a lawyer to review your agreement, and that's about it. So that is by far the preferred approach, but be very careful who you're dealing with. Okay, the next approach I'm going to put up here is called the mediated approach, and there are a million variations to having mediators mediate your divorce. There's a ton of variations to this, but generally speaking, it kind of goes like this. In the beginning, now this is assuming you're not on the same page with everything, but you think that if you had somebody else sit with you and kind of help you to negotiate with each other, you think you might be able to come to terms. That's called a mediated divorce. So what you do then is, in the start, again, I always recommend filing the papers together. That's by far a more transparent and less contentious thing to do. You file the papers with your state, your county, and then month one or two, again, you'll obtain all your records. You'll go through, get all your financials, all of your assets and things like that. And then it's best if you and your soon-to-be ex will sit together without a mediator, without anybody, and just see what you can agree on between the two of you and try to get as much agreement as you can before the mediator. Then when you go sit with a mediator, and there's a ton of different ones out there, I recommend getting one that is a former judge or a former lawyer, not just a mediator. Even if they're a certified divorce financial planner or whatever, that doesn't mean anything necessarily. Make sure you get a former lawyer or former judge or current lawyer. Those are the best ones to do it because they know the current law in your jurisdiction. So then you get with a mediator, you come prepared with all of your documents, and then you sit with him or her and you go through a parenting plan, division of assets, alimony and child support, and whether or not it's going to be modifiable. And that might modifiable or not. And that can take a long time. That can happen over many, many meetings. Or if you come prepared and it's not that contentious, it can happen in one sitting. I would be prepared to have several sittings. And I think generally it's best if you go together so there's full trust, full transparency. But if the trust is not there, you may want to meet with the mediator individually. That's kind of a touchy-feely type of thing to do. Just be aware if you meet separately with your mediator, it can have some kind of fog, like, well, what did she say? And what did he say? And is the mediator really being fair and representing both of us? So I think it's best to meet with your mediator together. Then in months, so you've met with your mediator, you've come to an agreement. Once you've come to an agreement, have a mediator draft something up, and then it's always best for each of you separately to have a lawyer review what the mediator wrote up to make sure it protects your individual interests. Now be careful there because lawyers are going to want to make this contentious and they're going to want to blow it up. So you may choose, and they may want to, kind of retain her and drag this thing out longer. So you might want to meet with one lawyer together to draft a formal agreement on what the mediator wrote up. But either way, then you present that to the court sometime in months 3 to 6, somewhere in there. And then just depending on how long your mediation took. Then you file that with the judge, you meet it with the court. You meet with the court 4 to 7 months out from your original start date. The judge will then go through your agreement again, make sure that you both understand it and it's fair, and they'll be done. Total cost of that process is probably 3 to 7 months usually, depending on how long your mediation goes. And usually it's about $3,000 to $7,000, depending on how much your mediator charges and how long you go to the mediator. So that's the second kind. So now we're going to talk about the third kind, and that's the horrible kind, and unfortunately that's the kind that I just went through this last year. And I call it the hateful kind. That's the kind where you don't trust each other, many deceptions have been done or whatever, and things are bad and things are ugly. Be really weary, because I went in thinking that I was going to have a harmonious divorce, and unfortunately was totally thrust into the most contentious, hateful, deceitful process that I could have imagined. So the way this hateful process typically starts is someone hires a lawyer, unbeknownst to the other one. That's what she did. Then the other person gets served divorce paper, just blindsided. That's what happened to me. Just shocked me. I mean, it just crushed me. So when you're served, then they'll file those with the court, those divorce papers, and that's what starts the proceedings legally. Then, so if you've been served or whatever, or make sure you get a lawyer. If you've been served, get a lawyer right away. Don't wait. Don't trust anybody. Get a lawyer right away. Then month 1 or 2 months after you've been served or the serving process happens, that's when you'll have an initial status conference with the judge over here. And in the initial status conference, they're going to talk about parenting arrangements. They're going to talk about temporary alimony. It's not a long-term lasting thing usually. And temporary child support. That's just to make sure nobody's destitute while you're going through the legal process. That's what that's all about. Your living conditions to make sure everybody's kind of safe and how you're going to live and things like that. And then typically in the initial status conference, basically that status conference is to say, what are we fighting about? What have we agreed on already and what are we fighting about? And then typically in that conference, they'll order you to go do discovery on each other's assets and things like that. And they'll typically order you to go to mediation these days. And they'll set a date for that. Typically in months 2 to 5, somewhere out there, that's when you're going to do discovery. And your lawyers are going to get all kinds of the financial records. They'll typically have appraisals done on your properties. They'll look at all your account balances, all your bank balances. Don't steal all the money. That looks really bad for you in court. Just try to be really honest, be really transparent, print everything out, get all your balances out there. Don't hide anything because that can come back to bite you. Then after you've done all your discovery, then typically in months 4 to 7, somewhere in there, you'll go to mediation. And in the mediation, you're going to go through those same things. The parenting plan, division of assets, alimony, child support, and whether or not you're going to do a modifiable agreement or not. That mediation in a hateful situation can be just one and done, where you meet with a mediator for a couple hours and say, screw it, we're done, we can't agree, let's go fight. Or it might go a couple of many sessions to try to mediate something. As the man's side, these videos are for the men. I'll tell you, try to mediate something, because men are really hated by the court system in America. It's best if you can work something out. If the mediation doesn't work, then in months 5 to 8 to longer, you're going to do trial preparation, and it's really stressful and really hateful. Trial preparation, you're going to get all kinds of witnesses about her character, about her work ethic, about her ability to provide for herself, her need for any welfare, basically alimony, from you, what her expenses should be, any kind of real estate appraisers or anything like that. You're going to get all kinds of experts about her state of being or mental health and things like that. You can choose to do what deposition, which is what we did. I'll talk about that in a separate video. Deposition can be excellent to really intimidate the crap out of her and let her know you're going to play real hardball when you get to trial. But ask your lawyer what deposition is. Then, typically in months 6 to 9, somewhere right before your actual trial, which is called a hearing, typically right before that, you'll have a last settlement meeting. And so that's without any mediators, without any other experts. It's just you, your lawyer, her, and her lawyer. Get into a room and just, can you work something out last minute before the trial? Now, in my case, we did, because the deposition was so intimidating that she knew she was going to get crushed in trial. And so in that settlement meeting, we actually came up with an agreement that was, hey, you're still going to lose as a man. The system's not fair for you. You're going to lose. It's just a question of how much you're going to lose. And so in that settlement meeting, I lost a lot less than I could have lost. And we came up with an agreement then. The lawyers drafted it up, wrote a memorandum of understanding. We presented it to the judge, and we didn't even have to go to a trial because that settlement meeting worked for us. If the settlement meeting doesn't work for you, then somewhere between months 6 to 18 months to 2 years, it can take a long time depending on how many issues you're fighting over, then you're going to go to trial. And it's going to be just like you see on TV, and it's going to be very contentious and very expensive with the judge. But at the end of that day's trial, it's usually a half a day if there's few issues, or a full day if there's a lot of issues. Typically at the end of that, the judge will either write a divorce decree that day, or some judges like to wait a couple of weeks to think about it, and then they'll write a divorce decree. But trial's your last event typically. Now, the cost to all of that hateful process is usually 6 to 18 months typically. And usually it's $15,000 to $30,000 each. That's $15,000 to $30,000 for you, and $15,000 to $30,000 for her. So it can be very, very expensive process. And it can go north of that. And then anything that a judge decides typically is modifiable in the future. So you can get an arrangement, and then suddenly you lose your job. Well, you can go right back in and get a modified agreement with the judge. Or the kids decide that they hate her and they want to spend all their time with you. That happens a lot. It happened in my situation. And if that happens, you can go right back in and get a modification of parenting time. So my deal that I did is non-modifiable. I don't have any intention to go in and modify any of it, even if I could. And the parenting time, we're just going to work it out. So that's kind of the divorce process. In subsequent videos, I'll go into a lot of other things in detail, but that kind of walks you through what you're about to expect and what you're about to go through. Remember, as a man, it's not fair. Don't expect justice from America today. Women had it a lot worse for centuries, and unfortunately, things are pretty equal today between men and women. But the court system is still set up to protect women as if they're still victims, as if they still need welfare and things like that. So don't expect fairness. Don't expect equity. If your soon-to-be ex is a wicked person, as mine was, you're going to pay through the nose, and it's not going to be fair. So don't expect fairness. Just get ready to fight. If you go into the hateful thing, you need to have a very aggressive posture, and you need to be lawyered up to the teeth. Last but not least, good luck. Don't lose hope. if you're mentally stronger than her, and if you don't break down, don't fall for your own chivalry. That's what I did. I offered the moon initially, which was a huge mistake. Men are often very chivalrous in these situations. Don't be. She's not going to be. She's out for herself. If it's the hateful kind, you need to lawyer up, and you need to remember you're the only one who really, really cares about your case. Your lawyer's doing it just as a job. They're going to help you, but you're just another divorce case to them. And the judge certainly doesn't care about equity for you. All the judges care about is getting cases through the system because they're so backlogged, and they just follow the law, and the law typically is very sexist in favor of women. So don't expect fairness, just expect to fight.